There we go. Well, good morning, everyone. My name is Ruth Bowdish. I am the Managing Director of On-Demand Occupational Medicine. We are a facility in Northeast Ohio that manages occupational medical needs from workers' comp care to drug screens, physicals. We also have a nationwide division that allows us to help companies across the country to achieve safer work environments. I've been blessed to travel the country to discuss many different topics from addiction to drug use and, of course, drug testing. Today, what we're going to be discussing is marijuana and oral fluid, the evolution of drug testing. Part of today's presentation is going to include understanding the landscape of marijuana in Ohio, which means we're going to be talking about issue 2. So that's where we're going to start. We're going to start with issue 2 and make sure that everybody is on the same page going forward with that. We're going to talk about oral fluid testing and why that's important for employers to understand, because there are some changes coming up in the next year. And then what the best practice is for y'all to be moving forward. Okay. So let's just jump right in. All right. Because I know that most of my presentations, I usually spend about 10-15 minutes about explaining what the problem is and why this is important. But I think we're all probably on the same page there. So I'm going to jump right into about issue 2. What is issue 2? Why is this so important to employers and to just, our state as a whole? Well, issue 2 authorizes and regulates the cultivation, processing, sale, purchase, possession, home growth, and the use of recreational marijuana by adults over the age of 21. As many of you know, medical marijuana has been legalized in our state since 2016. It went live in 2019. And so now we have recreational marijuana that is legal as of today. Today is when it goes into effect. So what does issue 2 mean to everyday life? Well, it's going to allow adults ages 21 and older to buy and possess 2.5 ounces of cannabis and 15 grams of concentrates per day. So it's not per week, per month, per quarter. It is per day, 2.5 ounces. It's also going to allow Ohioans aged 21 and older to grow up to 6 plants individually and no more than 12 in a household. Now, as I move through the presentation, you're going to see how some of these have changed. This is what issue 2 was at its core. Okay, so as it was voted upon. All right, there's been some changes. We're going to go over them, but this is as it was presented to the voters. So it would allow for no more than 12 in a household with multiple adults. Adult users could transfer up to 6 plants to another adult user, but you cannot accept payment for such transfer, and you cannot advertise it to the public, which means no buy, sell, trade, no Craigslist, if that's still a thing. None of those things can go forward. Also, dispensaries are going to be allowed to sell a wide range of products, from the flower to the seeds, edibles, vapes, tinctures, oils, beverages, pills and lotions, among other things. Now, Ohioans are able to petition state regulators to allow the sale of other forms of cannabis if those come up on the market. So we've definitely seen a lot of change where cannabis is concerned. I think many of us knew marijuana from in the 1900s, and that means smoking marijuana, in those kind of forms. A few edibles here and there, but certainly nothing like what's on the market today. Today we have our vape pens, we have our dab pens, we have edibles in all sizes, shapes, colors. We have CBD pillowcases, so I'm sure there's going to be some THC pillowcases. There's gum that has THC in it. So anyways, as new forms continue to evolve of marijuana, they are allowing in this law for those to also be petitioned for. It's also going to be taxing these products at a 10% tax rate, and the revenue has been designated to go towards administrative costs, addiction treatment programs, municipalities with dispensaries, and a social equity and jobs program. Like I said, there's been some changes, so we're going to go over those. Also, we know that the Division of Cannabis Control, which is within the Department of Commerce, is going to have to set up rules for licensing, testing, product standards, investigations, and more. As part of that, the division would set a THC content cap of at least 35% for plant material and 90% for extracts, which is quite high, considering that in the late 90s, we were looking at maybe 6 to 7% THC content. So it is a different product. Also, like the medical marijuana program, Ohio is going to offer 3 different types of licenses. There's going to be the cultivators, the processors, and the dispensaries. So that process is already into place. They're just going to be expanding that now to non-medical use. Landlords, by the way, will be allowed to prohibit home growth activities, but they do have to be specified in a lease agreement. If they are not, then the landowner cannot stop a tenant from utilizing marijuana in their property. Also, public and private employers will be able to develop your own policy for marijuana, such as rules around drug testing and use while on the job. I'm going to dive into that here in a little bit, like a little bit more specific, I guess. Also, recreational marijuana would still remain illegal federally as a Schedule I drug. So just because Ohio has legalized this, it does not mean that it is legal on a federal level. This is really important, especially if you're going to bid on federal or state government jobs, or if you're traveling across state lines. There are still rules here that need to be followed. Now, we talked about 2.5 ounces, or what the Ohioans are going to be allowed to purchase per day. Just so everybody understands, this is the amount that we're talking about when we talk about 2 ounces of marijuana. Just so you know, I want everyone to have that kind of visual image of what that looks like in their mind, so we know how much it is. Now, the restrictions that have been put forth on issue 2 include that minors under the age of 21 cannot possess or consume recreational marijuana, and they cannot have it on their person. They cannot go to school with this. They cannot be caught in their car with marijuana, regardless of the legality of it. Purchasing marijuana outside of a licensed dispensary will remain unlawful even after today. So that's kind of where we're going with this. So where are we going to buy it, right? We haven't figured that out yet. Until the first adult use dispensary opens in the state of Ohio, Ohioans that do not have an Ohio medical marijuana card will not be able to lawfully purchase marijuana in the state of Ohio. Yes, folks, that's correct. So we have legalized marijuana for use, but you are not allowed to buy it. Right. I'm not sure where to go with that one. But also no one is allowed to sell marijuana without an appropriate license. And there is a big to do about getting that license. It's not just going to go to anybody. There is a process that's involved, a lot of checking and a lot of things like that. Also, individuals are prohibited from operating a vehicle, motor vehicle, streetcar, trackless trolley, bike, yep, watercraft or aircraft while using marijuana, or if specific levels of marijuana or its metabolites are present in an individual's urine or blood. This has yet to be defined. So we have a kind of a blanket statement here, but with no defining tactics behind it. Also, those restrictions are going to continue on to tell us that public consumption of marijuana is prohibited. Cannot do it publicly. That means individuals are prohibited from smoking, vaporizing, or using any other combustible marijuana product while in a vehicle, motor vehicle, streetcar, trackless trolley, bike, watercraft, or aircraft. You cannot even, not only are you not allowed to possess it in those, you're not allowed to use it in those. So you cannot be smoking marijuana as you're driving down the road. And you cannot purchase marijuana in other states. There is currently no protections for individuals that are seeking to purchase a firearm. In other words, individuals are still prohibited from purchasing and owning firearms if you consume marijuana. Also, issue 2 does not provide employment protections. Issue 2 does not provide housing protections. There is no guarantee that adult use businesses will be available in your locality. Localities can adopt ordinances to prohibit adult use marijuana business, and we're already starting to see that. So Westchester Township has banned marijuana sale, cultivation ahead of new law taking effect. We also have Johnston, Township trustees have voted to prohibit marijuana processing or sales. So I'm going to guess, since they're leaving this up to the local municipalities, we are going to see a lot of this. Also, it's important to note that if a county does want to allow it in their county, they can exercise up to a 3% tax increase just for their county, just so we know about that. So in 2023, in November, a yes vote supported this ballot. It was put to the voters to issue the legalization. which allows the sale and purchase of marijuana, and we kind of went over that. So what's happened since then in the Ohio General Assembly is understanding how this process works. So even though the voters voted to legalize marijuana in that bill, in that original set of guidelines that we discussed, members of the Ohio General Assembly have already proposed to make legislative changes to several of the provisions of the new law. So legislative leaders expressed interest in making at least some reforms before it becomes legally effective. Again, that's today. The reforms were introduced to the General Assembly, and legislative hearings were conducted on some of those bills, including HB 86, which was just all done this week. Regardless of whether changes are passed, we're probably going to continue to see reforms on this bill into early 2024. The current status is that it is illegal until state regulators approve dispensaries. Licensing is not expected to be complete until summer of 2024. So purchasing marijuana outside of a licensed dispensary is going to remain unlawful even after December 7th. Like I said, we've legalized it for use, but we did not legalize the way of getting it. So, and we kind of did the same thing when we legalized medical marijuana. It's one of the reasons why marijuana was voted on and legalized in 2016, but it didn't go live until 2019 because they had to take 3 years to get all of those different rules and regulations put into effect. And now I don't think it's going to take 3 years for this by any means, but as you can see, there is still going to be some time that's going to need to be taken in order to get this to be lawful. On Tuesday, so this was 2 days ago, Tuesday, one of our Northeast Ohio representatives, Jamie Callender, became the 4th lawmaker to propose changes to the marijuana law passed. We also know that on December 7th, which again, today, certain provisions of that law will take effect. And we're going to talk about what actually happened there. So one of the provisions is the question is about homegrown. So issue 2 was originally written to state that adults over 21 can grow up to 6 plants in a locked enclosed area that is not accessible to children or visible to the public. One of the House bills, which is 341, they don't submit any change to this policy. House Bill 86, well, they want to ban home growth completely. And House Bill 354 preserves issue 2's homegrown provision. When we talk about tax rates, so issue 2 originally came out, voted by the voters, that there would be a 10% tax on sales of recreational marijuana products. House Bill 341 issues no change. House Bill 86, on the other hand, wants to raise that sales tax to 15% and add another additional 15% tax on the cultivators. Now, House Bill 354 said that 10% tax on sales of recreational marijuana products and a 10% tax on marijuana cultivators. The other question that was brought up was about the THC levels. Issue 2 said a maximum of 35% for plant material, 90% for extracts. House Bill 341, no changes. House Bill 86 says that we have to have a maximum of 25% for plant material and 50% for extracts. And House Bill 354, no changes. So what actually happened? Well, this is all brand new, headline news, just got it this morning. The Ohio Senate passed revisions to the state legalization of recreational marijuana before issue 2 became law on Thursday. So they did this last night. There's currently nowhere for Ohioans to legally buy it just yet, but the Ohio Senate did pass those revisions. And despite the bill clearing the Senate floor, the Republican majority House, which leans more in favor of overall recreational legalization than the Senate, believe it or not, has to continue to agree to all of these changes. These changes were now unanimously passed by that committee and cleared the full Senate by a 28-2 vote. This is all, like I said, done within the last 24 hours. Homegrown marijuana will be allowed at 6 plants per household, not 12. So they've changed that. They're saying 6 total for an adult in the household. Possession limits that were originally spelled out in issue 2 will not be changed, which means people can still have 2.5 ounces per day for plants and 15 grams of extracts per day. We also have THC content has been limited for plant material. will return to the issue 2 level of 35%. So they did not bring that down. Anyone 21 years of age or older can purchase at current marijuana dispensaries once bill takes effect. Issue 2 did not allow for existing dispensaries to start selling until 9 months after the law takes effect. So this means, as I said, anyone 21 years of age or older can purchase at current marijuana dispensaries. So that was changed. Again, all of this has just happened within 24 hours. Also, big deal here, automatic expungements for any conviction involving 2.5 ounces or below upon application to the court. Proceeds from recreational marijuana sales will be used for legal representation for those people that are seeking expungement. Increased the approved tax on sale of marijuana products from 10 to 15%, but it did remove the proposed 15% extra tax on cultivators. So what I'm saying here is that we definitely need to keep our eyes on this. I think that some of the bigger points that we can pull from this article is that they're stating there's an automatic expungement for any conviction involving 2.5 ounces, and that anyone 21 years of age or older can now purchase at current marijuana dispensaries once bill takes effect. So we're still looking at that. It could be today. All right. So probably should have had this presentation this afternoon. We might actually be able to figure that out. But I guess we can always look and see, will I be able to buy marijuana today in Ohio, right? Figure that out. So, as far as the financial outlooks for the state is concerned, adult use could potentially bring between $1 billion and $2 billion of businesses to Ohio. This is from Kessler. That's in addition to the $300 to $400 million in revenue collected from medical cannabis. According to a cost benefit analysis compiled in October by Columbus-based analysis group, the state of Ohio could generate an additional $190 million in tax revenue from legal adult marijuana use. And so this is what was presented to the voters, numbers similar to these, that this is what's going to be such a benefit. But if we look at other states and we kind of use them as a roadmap, the most significant cost that has been found was lost productivity from workers in specific industries. So this is going to affect all of you. States that have legalized recreational marijuana use on average experienced a 1% decline in productivity per worker. In Ohio, that could translate to approximately $760 million worth of lost productivity in the short run. And this came from Dan O'Brien, who recently penned an article for the Business Journal. So I do want to give him that citation there. So there's a lot of ins and outs to issue 2. One of the things that we talked about was that THC content. Also, many people who had voted for legalization thought they were going to be talking about marijuana for the 60s and 80s when the THC content was less than 2%. However, without any clear guidelines or regulations from government officials, the cannabis industry as a whole have developed strains of marijuana and concentrated marijuana products with much, much higher concentrations. We know that the more potent a drug is, the stronger the possibility of addiction, and the more likely the person is going to continue to purchase and use the product. We just know that from experience. Between 1995 and 2015, there's been a 212% increase in THC content in the marijuana flower. And in 2017, the most popular strains found in dispensaries in Colorado had a range of THC content from 17 to 28%. And if you remember, we just legalized in Ohio 35%. And that's not the concentrates, that's the flower, that's the plant. Concentrates are up to 90%. So how does marijuana use impact job safety? Well, I think we all know this. According to the National Institute on Drug Abuse, employees who tested positive for marijuana had 55% more industrial accidents, 85% more injuries, and 75% greater absenteeism compared to those who tested negative. We also know there's decreased productivity, increased worker compensation or unemployment compensation claims, higher turnover rates, and lawsuits. So what can an employer do? I know this is why many of you have logged in today, so I want to make sure that you guys get this information. According to issue 2, employers still possess the right to maintain policies barring the use, possession, or distribution of cannabis in the workplace. Employers are also permitted to continue to take action against employees' impairment, even when caused by off-duty usage. Remember what we say, a drug screen does not determine impairment, okay? We're going to talk about that also here in just a moment. Issue 2, employers continue to possess the right to create and enforce drug-free workplace policies, including testing applicants and employees for cannabis use. You can still take adverse employment relations against individuals as a result of their use, possession, or distribution of cannabis. So based on that above information, passing of issue 2 does not affect how employers handle marijuana cases. Employers can continue to bar the use of or possession of cannabis while on duty or on the employer's premises. It is also allowing employers to continue testing for marijuana and addressing those positive test results despite lawful and off-duty usage. Examples of addressing the results include adverse actions such as disciplining, dismissing, or even refusing to hire employees. So as we continue to talk about employer rights, like Ohio's medical marijuana program, the new law does not require employers to permit or accommodate an employee's use. Employers are not prohibited from refusing to hire, discharging, disciplining, or otherwise. There is no cause of action under the new statute for employees or applicants based on any such action by the employer. This is true even if an employee's marijuana use is lawful and off-duty. Now, this is very important. This means that if you terminate or refuse to hire a candidate because of a positive drug screen for THC, there are no legal repercussions based upon that drug screen alone that your employer, prospective employee, will be able to take against you. This is not how it is in other states. This is specific to Ohio. So if you are a multi-state employer, this is another landscape that has continued to change. You need to be well-versed in the states you are operating in and how their laws are written. In other words, just because you are based in Ohio, but you have employees working in New York, it is not going to be following Ohio law. It is going to be following New York law for those employees. So it is a changing landscape. And what we're going by are how courts are discerning employment cases. So every time a new case is handled by a judge, then we are told this is the way that it's going to be. So it is 3 years ago, this was not the advice that was given 3 years ago. It was where the company was based out of. That is not the case right now. So please know this, if you're Ohio and you're Ohio based and your employees work in Ohio, no worries. But if you're a multi-state, even if you're operating across the state line there in Pennsylvania, you better find out what Pennsylvania laws are, because that's what you're going to be held to. We also know that we can still continue to enforce those drug testing policies. And for the purposes of unemployment compensation, an employer has just cause to terminate an employee for use of marijuana in violation of the employer's drug policy. All right, so you have to have a policy that states implicitly you are not allowing marijuana on your job. Now, let's just say that I want to be real. Right? You guys, if you guys know me, you know that I'm always transparent. I'm always very, very real. Let's have a real conversation. The biggest problem that comes to our office is I cannot find good candidates. Obviously, nobody wants candidates coming to work that are high or drunk or under the influence of drugs or alcohol. We know that. That's kind of a no-brainer. But we're still getting a lot of people going, what are my options now that it's legally, legal recreationally? Maybe we have marijuana friendly companies, maybe they are pro marijuana. That's fine. judge-free zone here. I want you guys to know what your options are. Okay, so if you are a pro-marijuana company, then one option you have is to remove marijuana from your urine drug screen panel. You can still continue to test for other substances, and I encourage you all to do so. You might even want to look at including fentanyl in your testing going forward, mainly because we are still having a huge problem with meth out there on the streets, huge problem with cocaine and crack. Obviously, fentanyl and heroin and opiates are still the number one cause of death in America, cause of accidental death in America. We hit the six-figure mark in 2021 of people who have died. In 2022, we looked at about 110,000 people dying from drug overdoses. So obviously, we definitely want to encourage employers to continue to test. This is not something that we should think about getting rid of. The entire reason why employers are able to drug screen is because people died when they could not. So we definitely want to continue to do that drug screen. Just know that you can remove THC from that panel if you choose to do so. Just know that positive drug screen results are increasing in states with legalized recreational marijuana. So if you have a safety sensitive environment, this might be a little risky for you. So I'm going to have to kind of default to what you think is best. I just wanted you to know that the law is on your side as an employer. Okay. Another option, which I am so excited to be talking about here in a couple minutes, is going to be using oral fluid or saliva testing. It is a method that can detect active marijuana in the system rather than leftover metabolites. Let me have a little part here, though, that I really want to stress. We are saying active, not impairment, not impairment. That's very important. I'll talk about why that is here in just a moment, but I'm talking about active use. Active use. That's what saliva is going to be testing. Does not mean impairment. Does not mean impairment. So breath marijuana testing is also another situation that we're seeing coming out. It's not widely available just yet. I know that Quest Diagnostics is in the process of shipping equipment to collection sites. On-site equipment is available for purchase, but we do not have a legal standard yet to stand upon. Just note that whatever option you guys choose, make sure that your policy is allowing for the option of that testing. It has to be implicit. I cannot stress this to you guys enough. This here is a picture of the Hound Labs breath test that can be bought currently. One of the key questions that we cannot answer yet is whether breath measurements can be used to distinguish between a person who uses cannabis regularly but hasn't done so lately, or someone who consumed an hour ago. So we are still in the dark. Impairment still has yet to be defined. Now, if many of you are part of the BWC Drug-Free Safety Program, we know that this was developed to address workplace use and misuse of alcohol and other drugs. It is still very, very much in the forefront of safety for many Ohioans. Obviously, we encourage the BWC Drug-Free Safety Program. We know that it has saved lives in both creating safer work environments and providing a path to recovery. So we are huge, huge proponents over at On Demand for the BWC Drug-Free Safety Program. But yeah, they follow federal guidelines. So they state in their rules that BWC requires employers to arrange specimen collection and analysis that basically follows the federal testing model. And so when we are looking at this, we realize that the federal guidelines are going to be what creates our baseline, I guess you could say. Professionals have accepted this model for decades. It's going to be based on systems that have presents testing as the fairest way to ensure accuracy and reliability. It also has protections that have been built in for employee rights, including prescription verification that is done outside of the workplace, so we can still make sure that HIPAA and PHI are being protected. This is the gold standard in testing. An alcohol or drug test cannot be considered positive without a second or confirmatory test. It's also going to be measured against scientifically established cutoff levels, where a chemical metabolite is established to be within the employee's system at a level likely to affect safety and performance. What they state is at minimum, you have to have the same drugs that are required by DOT. Now, this is important for today's conversation because remember, marijuana is still illegal on a federal level. That means that if you're part of the BWC drug-free safety program, you are still required to test for marijuana in order to remain in compliance with the program regulations. So there's amphetamines, cocaine, ecstasy, those types of drugs that have to, at minimum, be at minimum be tested for. Now, you can choose to arrange testing for additional drugs, including those acknowledged as drugs of abuse in your local community, but you should not go less than the federal standard. So one of the questions that I get asked from a lot, and what are those panels? Well, here on your screen, you will see what it is: marijuana, cocaine, opioids, which includes 6-acetylene morphine, heroin, codeine morphine, hydrocodone, oxycodone, phenylephrine, can't say that word, it's PCP, just so you know, angel dust. And then we have our amphetamines, which is MDMA, which is also known as ecstasy. Okay, so this is the minimum. This is the minimum. Now you can add to, we obviously encourage you to do so. But one of the other questions that I get asked a lot is why follow federal guidelines for non-federal tests? Like, Ruth, I understand you're telling us about DOT, but I'm non-DOT. Why do I care if they're DOT? Well, let me answer that. 2 words: legally defensible. All right, legal defensibility can be defined as a company's strategy for reducing exposure to legal risk. It does not necessarily mean avoiding legal challenges to a drug test program or test result, but it does mean being in the strongest position possible to legally defend your program and each individual test result. So when we talk about the DOT as the gold standard, it is because that gold standard has been adopted as just, as fair, as defensible on a federal level, which means that it's going to hold more weight on a state or local level. Currently, there are only 2 drug testing methods that have been officially endorsed by the federal government: lab-based urine and lab-based oral fluid. Told you guys some big news coming down the pike this year. For 30 plus years, urine testing was the only method permitted for federal government mandated drug testing. But now we are now allowing for oral fluid testing. And this is a game changer. This is a game changer for a lot of people. And of course, lab results always need to be reviewed and verified by a medical review officer to rule out legally prescribed medications that could have a potentially positive result. Let's talk a little bit about the different types of testing because they don't measure the same thing. We don't use blood testing for employment purposes. There's just not a really kind of a platform for that. But we have oral fluid, urine, and hair testing. So if you look at the infographic on the page in front of you now, you're going to see kind of hours, days, weeks, and months, and you can kind of see how this looks. They are starting off based upon when can somebody find that presence. So if someone uses marijuana at 9 a.m. or cocaine at 9 a.m., oral fluid will be able to pick that up within 30 minutes. Urine, it might take a couple of hours, depending upon the person's metabolized. Hair, probably 7 days. So if you're looking for recent use, hair is not the way to go. Hair is going to be able to show us months of use, up to 90 days, usually up to 3 months. And so, if we want to do hair for random testing, but pre-employment, it's not really going to be giving you that window that you want or that you need. So another question I get is, why can't we use drug screen levels to determine frequency, quantity, or impairment? Well, the interval of detection can vary based upon the following information: the type of drug ingested, individual's metabolism, amount of the substance used, how long they're using, how often they're being tested, the sensitivity of the test, the specificity of the procedure, consumption, age and sex of the testing applicant, food and water. Okay. What I'm saying here is there's a lot of reasons. People will often ask me, "Hey, Ruth, what are the levels on that drug screen?" Oh, and I always cringe. Most of the people here, if you guys know Greg, you guys know Mariah, most of the people here that you're going to call are going to say, "You know what? Hold on a second. Let me get Ruth for you." And the reason being is because I'm just so very hesitant to give out that information. It is not a standard for employment drug testing to have the levels presented. We know that there are gauged against a baseline or threshold level, and that's that legal defensibility. So we do that. That's not a problem. But I usually want to have a little bit of a conversation because at On Demand, we're not just doing drug testing. We are also making sure that we're providing a good program for individuals. So if you want the level, I'm just going to ask, what you can't use it for employment purposes. And it's not always going to tell you the information that you want to know. Recently, I had someone who was asking me for the levels, and they wanted to know if they had used that day or the day before. And I was like, well, believe it or not, the levels aren't going to indicate that to you, because it could be the concentration of urine. And as you can see, it varies greatly. You could take a drug screen in the morning and another one in the afternoon and have two very different levels. All right, that's urine testing for you. Urine testing is the gold standard, pun intended. It's legally defensible. It's less expensive than any other testing out there. There is a wider array of panels that are available because it has been around for so long. But on the downside, it is easier to cheat. I cannot sit here and tell you that nobody ever gets away. We work very, very hard, as I'm sure other drug testing agencies do, to limit the amount of fake urine coming through. But every now and again, we do get a couple that pass through. So it is, a lot of those different issues there. So also, it's time consuming. I'm guessing if you guys do drug screens, you've always had like at least one time an employee who couldn't produce. And what are they doing? They're off the job for 2 hours while you're paying them. Like, who wants that? Sometimes it's unavoidable though. And so that happens. Plus, we also look at detection time can goes from days to weeks. It also can pick up recent use, but marijuana in a urine drug screen is not going to indicate whether the use was that morning or 2 weeks ago or even a month ago. You're not going to be able to tell that with a urine drug test. All right. Also, another thing I want to touch upon quickly today is the difference between instant drug screens and lab sendouts. An instant point of care, instant testing, rapid drug screen, whatever you want to call it, they are unable to provide quantifiable results. There's a higher probability for interference. There's a higher rate of false positives. They are indicators, but they are not going to tell you the whole story. They are also not legally defensible for employment decisions in the state of Ohio. They are also not recognized by the BWC or DOT. We look at these as, like I said, as indicators, but it is quite common for an instant to show a positive and it goes to the lab and it comes back as a negative. Also, you just don't know what kind of interference there could be. So one of the best cases of appropriate, in my opinion, instant use is we work with several unions, and the unions have usually very robust, very thorough drug testing programs with randoms and annuals and all of these other things. Every now and again, a worker will get transferred from one work site to another, and they require a drug screen. Since they're already part of a random management program and they're already going to be tested with a lab, if they need to do a point of care instant test to get on the job site, as long as it's getting sent out for any positive, that's fine. But for employment decisions, you always kind of want to be a little bit, hesitant. Usually a negative is a negative, but a positive should always be confirmed, always be confirmed. Also, with a lab-based send out, you're getting those quantifiable results, which are measurable. You're having that confirmation testing, so there's going to be two tests for every positive. You're going to have the initial test and then the confirmation test when it goes to the lab. You have a high level of accuracy, over 99.99999% accurate, which is going to stand up in a court of law. It's going to be able to measure levels over a period of time, and it also looks at adulterants and dilution. To be fair, some instant tests do. They're just more expensive. And then we have our hair testing. It's very expensive. It's also very hard to cheat these tests, though. It does show a bigger picture, a point of view, but it does not pick up recent use. It usually picks up 4 to 7 days. So if you think somebody's on the job and they're using, hair test is not going to indicate or confirm that possibility. Now we move on to oral fluid testing, which has grown leaps and bounds over the last 5 years. It is more convenient and less invasive than urine testing. There is a shorter detection window, though. It's hard to cheat these tests, but it's more expensive, at least for now. So let's say that a standard drug screen is going to be between $40 and $45. For oral fluid, you're looking at $55. So it is a little bit, and that, obviously there's going to be $50 to $60, we'll say. So there is going to be a range. But if you look at that reduction in employee time spent taking the drug screen, for a lot of organizations and companies, it's going to be worth it. As we move towards a federal standard, though, in 2024 for this, we are going to see those prices, I'm sure, come down because it's going to become more and more competitive. Still does not determine the impairment, but I want you guys to look at this screen and I want you to think about this, okay? Oral fluid detection guidelines look at cannabis, marijuana 24 hours. So we're looking on average between 1 to 3 days. Standard is being about 24 hours. So again, not impairment, but it does detect recent use. And if you are worried about individuals for pre-employment purposes, oral fluid might be an excellent way to go for that. If you're worried about post accidents or, reasonable suspicions, those types of things. I do want to mention when I talk about post accidents, by the way, that having a positive drug screen does not negate an employer's responsibility for the claim. It becomes very, very difficult. And I would definitely defer to some BWC reps. We have Brian Zacchetti, Christine Williams, Michelle. There's a lot of great BWC reps that we have in our area. So I would encourage you to talk to one of them for more thorough information. But I will tell you that it has to be proven that the accident would not have occurred any other way except if that person had been not under the influence, right? So it definitely, so I'm not going to sit here and say that a positive drug screen for a post-accident is going to negate the claim or financial responsibility from the employer. It doesn't do that, but it could indicate some causality, some situations there. So we still encourage you to do it, but two different things. But as you look at the detectable in saliva, codeine, fentanyl, heroin, hydrocodone, all of those things are going to be able to be found in the oral fluid testing. Now, as I mentioned, DOT, golden standard. Well, the Department of Transportation has published a final ruling to expand its drug testing procedures to include oral fluid testing effective June 1st, 2023. This is a significant change. Previously, they only allowed urine drug testing. So now we are able to have some new rules that we all get to follow. So the DOT's new final rule gives employers the option of using a urine or oral fluid test. Now, this is where it becomes we're going to muddy these waters a little bit. Okay, guys. The rule requires employers to use oral fluid. Now, this is DOT. These are DOT rules. You can adopt these as non-DOT employers, but this is what DOT is saying for DOT employees. It is requiring DOT employers to use oral fluid testing for transgender or non-binary individuals, and when a direct observation is required, but a same gender technician cannot be found. So if you have an individual who is identifying as a female and there is not a female collector to go into the restroom with that individual, we have to use an oral fluid in order to make sure that everyone is equal and treated as fairly as humanly possible. The new rule did become effective on June 1st, but employers will have to wait to implement oral fluid testing until the U.S. Department of Health and Human Services, HHS, has certified 2 laboratories capable of processing the tests. Currently, the HHS has yet to certify these laboratories. We have laboratories that will process oral fluid today. Okay, so don't let that stop you from moving forward with oral fluid testing. That is for DOT purposes. So we definitely have oral fluid testing available today, but if you are DOT, you have to wait for those labs to be confirmed. And since DOT is the golden standard, well, you may want to wait as well. So that's kind of an internal conversation with you. But I will tell you that you're going to have to revise your written drug and alcohol testing policies. If the policy specifically states that urine is the only specimen authorized for drug testing, you will need to update that to read urine and or oral fluid. Now, I'm going to give you guys an example of what's happening in California in 2024. A lot of times things start out on the West Coast and they move over east. So just kind of giving us the information here. Starting January 1, 2024, California employers will not be able to turn away job applicants or employees just because they legally use cannabis. So what's happened is that they have a new level of protection for cannabis use that's off duty. Remember, no one's allowed to come to work impaired no matter what. So it fundamentally alters the way employers may test for it moving forward. What the law goes on to say is employers can't discriminate against those who use marijuana outside of work, but they can still test for substances. All right, they can still test. So they're not saying anything about any other drug. You can still drug test, just can't use THC, can't test for that, unless you're using different methods for marijuana testing, i.e., oral fluid. So what they're saying in California is that for pre-employments, for THC, randoms, any of that, you have to use an oral fluid. You cannot use urine any longer. Traditional urine tests for marijuana will not be permitted anymore because they can come up positive even in cases where marijuana has been used weeks prior, and that is 100% correct. So if you, as the employer, authorizes oral fluid testing, the policy is going to need to state that the testing events, i.e. pre-employment, reasonable suspicion, so on and so forth, for which an oral fluid collection will occur. Your collection site, your TPA, even your trainer cannot make that decision for you. That is an internal decision that is going to be employer based. An employer can use one or the other, but not both at the beginning of a testing event. So if there's a problem in the collection that necessitates a second collection, so if we have insufficient quantity of urine, like a shy bladder situation, if the temp is out of range, no, you guys got a lot of that happening, or if it has insufficient saliva, then a different specimen type can be chosen by the employer. All right. It's very important that if you guys want to move in this direction, that you get a standing order with either an on-demand or whoever it is that you're using, so they know exactly what your procedures are, because what you do for one, you got to do for everyone. So you need to have a standing order in place. If there's no standing order and the service agent cannot contact the DER to complete the collection process for the testing event, then we cannot move forward. Okay. So as far as the official rules and regulations here, the policies are going to need to state whether oral fluid collections will be authorized and under what circumstances. Oral fluid collections must be available for directly observed collections. Employees do not have the option to choose the testing methodology. It has to be an employer. So if we got somebody here and they say, just give me an oral fluid. Does not work that way. An employer has to make that decision. Employers should have a standing order in place with each collection site so that they know what kind of collection the employer wants performed, whether it is, urine or oral fluid, things along those lines. So you also need to use those certified laboratories, which again, we do not have that just yet. So we are able to do that as we look at 2024, but we're just not there quite yet. DERs are required to be available to collectors 24 hours, 7 days a week. So we have to know who at the company we can get a hold of if there's a problem. It is going to be especially important to ensure that collectors are carrying out the employer's standing orders. You cannot leave it up to the collector to make that decision. They can't do it for you. They're not allowed, okay? It is the employer's responsibility to determine when a refusal has occurred at the collection site. A collector may advise that something appears to be a refusal, but a final determination is the employer's responsibility. So keep that in mind, okay? Now, remember what we've talked about. Drug-free policies are literally saving lives. You have to understand the importance of a drug-free policy. You want to know that it's creating safer work environments. It's helping to identify personal problems that can get better with treatment, and also understand what your options are. Even in this changing landscape, you do have options. You can remove THC from your panel, or you can switch to oral fluid that has a shorter detection window. And ultimately, what I want you guys to do is to ask questions and to become informed, because it is important that that those questions are asked and answered. So speaking of which, I am going to go ahead and allow you guys to unmute yourselves. And I'm going to look here at the questions that have come through here to see if we have any here that I can answer. So let me start here. How does a positive test impact a workers' comp claim? That has not changed. So whatever had happened previously with that, it's going to be a case-by-case basis. If you have a not allowed policy, look at it like alcohol. You know, if it's a positive, it's a positive. It's not going to necessarily impact workers' comp claim. It's hard to answer that question because each claim is going to be looked at differently. But it does not automatically negate that. So as far as, can you guys get a copy of these slides? Yeah, no problem. I would ask you to email me for a copy of those slides. I would love to say that I'm going to sit here and remember all of you, but I will not. Sydney, our lovely Sydney, who is our marketing guru, might have a way of us posting the slides, Sid. I'm not sure, for us to put those someplace where people can just access that. I'm not sure. Maybe we'll find some creative way of doing that, but we'll let you guys know. We'll definitely get a copy of the slides. And someone has asked for an in-service. 100%, I would encourage, you know, as much of this information to get out to the public as possible. If you are going to be a company that is not marijuana friendly, they are not going to allow marijuana. First of all, the law is on your side 100%. So do not worry. Does it limit the amount of people that you may get applying for your jobs? It might, but you know, the alternative is that you're getting people who are using marijuana then. So it depends on the industry. It depends on your company, right? Like it's a judge-free zone, but you definitely have to have that conversation now. And if you are not allowing marijuana, I suggest you all to update your policy. But again, law is going to be on your side. And I would definitely suggest a training or an in-service for your employees to know we do not want to set anyone up for failure. We want to let people know that it is, even though it's legalized, it is not okay. And supervisors, definitely, if you are going to allow marijuana or not test for marijuana, then I would definitely also encourage you guys to have that training for your supervisors to become more aware of reasonable suspicion rules and regulations, signs and symptoms. Yeah, slides. Do I have a standing order template? That is an excellent question. I do not, but we will get one.
Yes.
I've got Greg here. For everybody that knows Greg, that's who I'm looking at right now. Greg West, our business developer, and we will get that. We will get that. Meg, that's a great question. I appreciate you asking that question. We will get a template for a standing order for you guys. So nobody has access to a DHH lab right now. Nobody has that. It hasn't been, it's not there yet. They have not created that yet. So we do not have an HHS lab that has been approved as of today. They're looking to have this approved by March of 2024, but that could be pushed out, could be, you know, coming back. We don't know. We are waiting to hear on that. We have labs that can do confirmatory testing on it. It is not going to be an HHS lab as of today. And again, it's not just on demand that doesn't have access. They don't exist. Nobody has access just yet. So your option would be, in that case, if you do want to switch to oral fluid right now, you can definitely switch to oral fluid. We work with several labs. Omega right here in Northeast Ohio is a great lab, and they do confirmatory oral fluid testing. The difference is that designation. Okay, so if you're non-DOT, you can still do this. You're still going to have that confirmatory test. It's just not going to follow the federal guidelines for BWC or for DOT. All right. I'm reading another question here. If a female isn't available to go into the bathroom with a transgender or non-binary, an oral test is completed, is that the same place for females and males? Yes. So what they're saying is, if for DOT, again, I want to make sure I'm stressing this for everyone. DOT has made a rule that states once an HH lab has been approved, that means that you have to offer a non-binary or transgendered individual the opportunity to use an oral fluid testing device when a direct observation test is required. So think of return to duties, follow-up testing, out of temperature. If there is not a same gender employee, a collector available for that, or they are non-binary, or they are transgender, or they do not wish to discuss or disclose their gender, they are under no obligation to do so. At that point, we have to switch to oral fluid. But for non-DOT, hasn't been, that's not That's not a mandate just yet. It is for DOT once that HHS lab has been designated. It is the same rule in place for anyone who is non-binary, anyone that's transgendered. All right, Sid has commented that they'll be able to email them out. What is my email address? That's a great question. Here is my contact information. Okay, there you guys go. It's right on your screen for you. For slides, please reach out to either myself or to Ruth. Contact information, that's Sid. What is a standing order? Okay, so a standing order is kind of like a rule guideline set that's going to specify from an employer, if my employee offers an out of temp specimen, immediately switch to oral fluid testing. That's a standing order. So we know, or any collection site that you may use, so that we know what to do in those circumstances. It's been that we've just followed the same rules for 30 years. So that's never caused into question. We've never needed standing orders before, but we do now, because there is a possibility that you could choose oral fluid testing in the future to do so. So that's what that is. And then, oh, she got my contact. Thank you. Oh, Clarissa, I didn't know you were logged in today. It's always good to see you. Appreciate that. And I will be more than happy to do another webinar. Actually, Sydney and I were talking about maybe doing like a lunch and learn right after the first of the year in January, just to kind of see what else has transpired in the next month or so. So maybe look for that maybe end of January, beginning of February, where we'll have it here at our office. We'll do it in person, and we can maybe broadcast. We'll have to look into that. And oh yeah, so the breath testing. So there are breathalyzers for marijuana that are being utilized. Quest created one. There's one that's by Hound Labs. And so it does detect recent use, but please keep in mind, they do not work the same as alcohol breathalyzers, because alcohol breathalyzers are going to be measured against a standard that does not exist for THC. If you have a breathalyzer and it's above a 0.08, it's against the law. You can't be at work above a 0.04. We have these numbers. Those numbers do not exist where THC is concerned. In other words, we have not yet defined impairment. So you can do as a breathalyzer, but as far as employment is going to be concerned, it might indicate recent use, but it does not define impairment. So they are available out there. We do not have one here at On Demand. If they become regulated like a regular one, of course, we're going to get one, but we're going to be waiting to kind of see how that works. Right now, the best option that we can see moving forward for companies who are concerned is that oral fluid. We are very, very excited about oral fluid testing. We are very excited to be moving forward with that in the coming months, because I think it solves so many problems for our companies. We get just all the time, we get companies and DERs on the phone with us who are going, what am I supposed to do? We want safe work environments. We don't want people coming in high, but if I keep marijuana, I'm not going to get any job applicants, or people are going to quit and they're going to go to the company across the street that is not testing for marijuana. So what am I supposed to do? And I just think that oral fluid testing, in my professional opinion, is the answer to that question, because it is going to shorten that detection window. And still not impairment, right? We're still working on that. Science has got to catch up, but it does kind of help us to kind of navigate those waters, I think, a little bit better. So are there any other questions that you guys have? These are wonderful questions. Really appreciate the engagement. You also can unmute yourselves. So you are able to do that if you would like. I'll just pause for another moment. All right, we're going to go ahead. I'll get those slides prepared, and also I'm more than welcome to come out on site and do these types of trainings. On Demand is fully serviceable as far as reasonable suspicion testing, training, and as well as employee education. And as always, we're here to help you guys. That's what we do. So we're here when you need us. If you guys have any other questions, don't be afraid to reach out. Happy to do so. Otherwise, it is promptly 11 o'clock. So I'm going to go ahead and sign off, but you guys have yourself a great rest of the day, and Merry Christmas. Happy New Year to everybody. Stay safe out there. Okay. Thank you again. Hey, Megan, are you still on? I just saw a question pop up. I think you may have logged off.
No, I'm still here.
You're still here? Okay, great. I'm so sorry. So
I don't know if my question, if I typed it quite clear enough. I was just wanting to see, I think it on your slide it said 24 hours. I just was curious, like the time frame that it remains in the oral fluid.
it's usually 1 to 3 days. So it depends. So the average is 24 hours, but it's going to be between 24 and 72 hours on average that it's
So
going to stay in the system detectable.
capturing that and then it is gone again. Okay.
Yep.
That was my question. Thank you.
All right, great. No problem. Thanks for asking. I hope you have a great day.